Welcome to our first class. In this first lecture, we'll be covering the fundamentals of good U.S. legal writing, and we'll take a close look at a few examples of legal writing to see how they're strong, or not so strong. If you're having trouble understanding anything I'm saying, try turning on the closed captioning setting on YouTube. So let's get started by looking backwards a couple of centuries to the 5th century, when a guy named Phidias, who was a Greek sculptor and mathematician, designed the Parthenon in Athens, Greece, according to a principle called the golden ratio. If you look at this, you can see that there is a square and a bunch of rectangles within the rectangle, then more within, etc., etc. This was all important because to the Greeks, beauty was all about balance. This is what the formula actually looked like for phi, or the golden ratio. Leonardo da Vinci used it. For centuries, artists and architects alike thought it was the perfect standard of beauty. But as it turned out, like most things, it was too good to be completely true. And in fact, it was more of an ideal concept that people imposed onto existing reality. It was a good way to explain the structure of beauty, why something looks good. Which takes us now to our domain of the arts for the semester, writing. Okay, so first of all, is legal writing art? I would say yes. Art can be highly logical, like the Parthenon's rectangles or the music of Bach. It can be exacting as a formula. And the more we realize that legal writing is an art, the more we can become better creators of that art and have fun with it, hopefully. I also want to point out that there are two symbols of very common U.S. iconography for the justice system right here. I'm sure you have the same implements in your own offices back at home. Okay, so then what makes legal writing actually good or beautiful? Here's a take by a professor from the University of Michigan, Mark Osbeck. Now, I like what he has to say and his bottom line idea of what makes legal writing good. Legal writing is for decision makers, and therefore good legal writing is best understood as writing that helps legal actors make decisions. Legal actors, I would say, are not just judges and clients, but also attorneys, especially senior attorneys that we work with. Okay, then what is the actual golden ratio, if there is something like that? What are the standards of good legal writing? Osbeck gives us 3 ideas: clarity, conciseness, and the ability to engage the reader. I think these are good rules of thumb. So starting with clarity then, let's talk about Kanye West, who's a rapper and singer-songwriter. He's notorious for not being clear. It's easy to look at any of his tweets and find a lot there. Truth is my goal. Controversy is my gym. I'll do 100 reps of controversy for a 6-pack of truth. Now, I think what's interesting about Kanye West is that it almost makes sense, you know what I mean? But the feeling that we have of unclarity when we read his writing is a lot like how we feel when we read other things that are unclear, even in legal writing. There's just something about the connections of one sentence to another that don't quite make sense. The transitions don't quite make sense. So let's break it down a bit. All right, so Kanye starts out by saying, truth is my goal. You know what? That's not bad. That's a thesis statement. Good, simple, declarative statement. Truth is my goal. Controversy is my gym. Okay, all right. Is that an antithesis, an opposing thesis, or maybe a rivaling thesis, or just an illustration? Not really sure. I'll do 100 reps of controversy. Okay, this is where we would naturally expect something to tie up the first 2 statements, but it doesn't quite do that. We don't quite get a synthesis. So what's the takeaway? Why are we even talking about Kanye West? I think it's this. As people, we instinctively always want to connect one sentence to the next, one idea to the next, even if it's something that's not persuasive writing or expository writing, as legal writing usually is. Our minds just don't like confusion. We don't want to see a bunch of tangled wires. We want to understand the connections. And that's the key to clarity. All right, what about that second feature of strong legal writing, conciseness? Now, there is nothing more American than the desire to get to the point. We say short and sweet, right? You've probably seen this meme before from a long time ago. Too long, didn't read. I would say this because, especially if you've been educated in a legal tradition where more words equals more authoritative or more smart sounding, that is the opposite of the U.S. legal tradition. But let's go back in time a bit. So this is a clip from one of my favorite novels, actually, by a turn-of-the-century writer, Henry James. I'm not going to read it out loud, but you can see how long these sentences are, right? How many clauses there are within clauses, interrupting each other, how much excess information there is. The one thing I want to point out is at the end, you get this double negative. There's never a moment of her life when she wasn't due somewhere. There was yet scarce a perfidy to others of which she was incapable for his sake. What does that mean, right? I think he means that for his sake, she would have committed any perfidy for others. But he states it in the negative. And one thing we can draw from this example is that when we use straightforward, pretty short sentences, we're going to sound more concise. And the active voice sounds more concise than the passive voice. And positive statements of ideas, rather than negative ones, will also be easier to understand and therefore be more concise. All right, so what about less obvious examples of not being concise? Here's a legal one from the Department of Justice's Office of Legal Counsel. This was a very timely memorandum opinion issued by the OLC about whether or not the Inspector General of the Intelligence Community was correct in determining that the complainant's report was about an urgent concern. And he said it was not. So I'm not going to read all this out loud. You can see it is a big wall of text. You can see there's a lot of fact, and that many of the sentences start out with something like the complainant alleged, or specifically the complainant allegedly heard. So thinking about conciseness for that example, because it wasn't that it had a lot of excessive or flowery words, right? It's hard. So I want to try rewriting it briefly. What if instead of repeating each sentence with allegedly heard, we said it once? What if we use bullet points and then also created white space? Doing something like this might not look good in their style book, but it would allow a reader, a judge, or an attorney to be able to isolate the different facts and understand things. Then here, I've taken a confusing sentence and tried to reword it to be clear that it's the president that asked investigators to meet with his personal lawyer. All right. How about then the most fun part of our three-part look at legal writing, the most artistic part, engagement. This is another way of saying try not to bore your reader. So what we'll do is look at a case and parts of a brief written by Gibson Dunn on behalf of Apple. Here's what happened. The FBI had a big criminal investigation. It needed access to an iPhone, which at the time was really hard to hack into in 2016. So it asked Apple, "Hey Apple, will you unlock the phone for us?" Apple said, "What? No, we're not doing that. Privacy, trade secrets." The government then sued Apple under an ancient statute called the All Writs Act. Then Apple, of course, fought back and opposed an order that the government got to require Apple to unlock the phone. So what we're going to look at is a portion of the brief that Apple filed in trying to get that order vacated. Here's the introduction of that brief and the very first paragraph of that brief. I'm going to read this out loud, kind of dramatically, to give you a flavor of that rhetoric. The Justice Department and FBI are seeking an order from this court that would force Apple to create exactly the kind of operating system that Congress has thus far refused to require. They are asking this court to resolve a policy and political issue that is dividing various agencies of the executive branch as well as Congress. This court should reject that request because the All Writs Act does not authorize such relief, and the Constitution forbids it. Okay, so what's the structure of this paragraph? It's very short. First of all, it's just 3 sentences, right? So you see the first sentence, not too long, pretty straightforward. It's what we would call a declarative sentence, simply stating what is. It is describing what is going on, telling the court basically, hey, this is what the bad government is looking for. All right, the second sentence, even shorter. Another declarative sentence, more description. But this time it's broadening the context and saying, you know what? Courts should not be interfering in policy and political issues. The third sentence, though, feels different. It's a different kind of sentence. It's the first time the government is asking the court to do anything. It's very short. And in this one short sentence, the writer makes a direct appeal and explains the reasons for it in pretty broad and bold terms. All right, think back, by the way, to Kanye's tweet. There was only 3 sentences, just like this. All right, so here's the next section in the brief, right in the same argument section. It's fairly long. It's not perfect, but I find it very engaging. Why? Let's break it down a little bit. The first device that this writer uses is a classic one that's used in literature, metaphor, or simile, which is just comparing one thing to another thing that's different, although there's some sort of shared common feature. Even in legal writing, though, metaphors can be used to enliven. They bring us back to our sensory associations. So when the attorney writes, the act can't be stretched to fit, he's making it sound like the act is physical. Or the government wants to wave an all-powerful magic wand. Or short of kidnapping, they read the act to mean anything that they want it to read. These things make the examples come alive and make us remember what they're saying. The second device that this attorney uses well is what I call reframing. By this, I mean analyzing something that's already been written down and then giving your reader the gist of it, boiling it down, vividly summarizing it, and trying to recast it in a memorable way. So here, the Apple attorney is saying, the government wants to rewrite history as theorized by the government, etc., etc., etc. Or, according to the government, basically the court can do anything. They can order private parties to do anything. This is an effective way of providing distilled analysis while giving your reader your own viewpoint. And the third strategy that the Apple attorney has used is hyperbole, or exaggeration. Now, I would say hyperbole is dangerous if you're applying it to the facts. You cannot be inaccurate as an attorney, but you do have freedom to use hyperbole when you argue or present opinions, as long as you do it within reason. So here, the attorney's right, all-powerful magic wand, because a sort of powerful one is not very interesting, right? And the founders, our founding fathers, would be appalled. Well, maybe they would have been a little bit annoyed, but it's definitely more entertaining to say appalled. All right, so those are 3 devices that they used very well in this brief. Now, I'm going to read this next little section from the brief out loud, and you try to find the places where they used metaphor, reframing, and hyperbole. The government portrays the All Writs Act as a broad, venerable, fluid, adaptable font of virtually unlimited authority, empowering courts to issue any and all orders that the government requests in the pursuit of justice. As the government tells it, courts can wield the flexible power conferred by the Act until Congress expressly takes it away. This is an exercise in wishful thinking, not statutory interpretation. Okay, here's a metaphor that I would say it's not a font like a writing font. It is a fountain that spews all this perceived authority. Here's some reframing. The government portrays the All Writs Act as all these things. And here's some more reframing. As the government tells it, blank, blank. Here's a little bit of hyperbole, virtually unlimited authority. And then, of course, the best part of it, wishful thinking. Notice also how this last line is very short and punchy. It starts with a very simple word, this. That is a plain declarative sentence. It's like a definition, and it grabs our reader's attention. So now that we've returned to the Parthenon, you can probably tell we are almost done. We've covered our 3 grounds of good legal writing: clarity, conciseness, and engagement. Now, obviously, like the actual Parthenon, these aren't really part of a truly perfect formula, but we'll use them as a good start. And throughout the semester, we're going to keep refining our definition of what it means to write well in the U.S. legal tradition. And maybe, just maybe, by the end of the semester, you'll agree with me that legal writing can be beautiful.